The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
A Washington jury delivers their verdict in the murder case of an unfaithful fire chief whose wife died suddenly. And in New Mexico, released with restrictions. Actor-director Timothy Busfield gets a win in court today. What does this mean for the child sex abuse case against him? And take a look at this photo. A man arrested at the scene of a suspicious death, caught wearing something that could speak louder than his own defense. The court of law is done for the day in these cases. Let's call to order Court of Opinion. Welcome to Court of Opinion. I'm Jenaé. Thank you for being with us. We are heading right to Washington State, where the jury reached a verdict today. A fire chief on trial for murder alleged it was just a coincidence that his wife died naturally on the same day he planned to leave her for his mistress. Former Battalion Fire Chief Kevin West even took the stand to try and convince a jury of 12 that it was a seizure, not strangulation, as the medical examiner found, and that the damage to her body was perhaps done by a massage or life-saving measures. So here's a look at how the verdict came down in that courtroom.
All right, verdict in count 1A. We, the jury, find the above-named defendant guilty of the crime of murder in the first degree. Verdict count 1B is blank as required. Verdict count 2A, we, the jury, find the above-named defendant guilty of the crime of murder in the second degree. Special verdict form were Kevin West and Marcel West, intimate partners. Answer is yes.
Kevin West there shaking his head no to the guilty on all counts that came down from this jury. And now he faces sentencing on February 27th. He'll get another opportunity to speak at that time. But in case you missed it, here's a look back at West's testimony on both direct and cross on Friday.
How was your marriage starting out?
I would race down there just to see her during the academy. We were very much in love. We were a very good team as parents, and right from the start, I was very engaged as a father, as she was a mother. My emotions went back and forth because we had so many problems that were unresolved that I was sad. I was frustrated. I was angry about that. But there's also someone I love for
Were there
a lot of years. Sorry. The two of us didn't have a plan. She threatened to leave many, many times. I would ask her not to threaten that. I wanted to work on things. Over all the years, especially after 2015, I came to the decision that I was going to wait until Megan got out of high school and graduated, and then I was going to move forward with a divorce.
How about in the last, let's say, 6 months of the marriage, were you sleeping together at all?
Yes.
Like same kind of pattern?
Yeah.
And were you having any intimacy with Marcy, let's say, the last 6 months?
Yes.
How often?
Once a month or once every other month.
Of course, at this time, you're seeing Cynthia, correct?
Yes.
You're being intimate with her in the last few months, is that right?
Correct. I felt it's not quite a vibration. I think it's easiest to feel it's not quite shaking. It's not like I was experiencing an earthquake in bed, but I could feel movement in the bed.
And what did you do next?
I put my hands on her, and I could tell she was shaking, and something was wrong. Immediately, I'm considering, seizure in my mind, obviously right away. One arm underneath her shoulders and one arm underneath. And as I brought her out, I brought her to my knee, and then I brought her to the floor. I couldn't support her weight. She was, I couldn't support her and even lift her and then set her down, but I brought her to my knee.
Kevin, did you put your wife in a rear naked chokehold and strangle her to death?
No.
Did you do anything to cause the contusion on the back of her head?
No, I did not.
Did you do anything to cause Marcy's death?
No, I did not.
You told your best friend, Kevin Valines, that you feel bad for not feeling bad, and that was at 8 a.m. the morning of Marcy's death. Did you not?
That's what he testified to. If I said something to that effect, that morning was beyond traumatic and difficult. I don't know half of what I said. I was also frustrated with dispatch. I was frustrated that I couldn't do continuous CPR. It was difficult.
You told your best friend, Scott Slocum, that a burden had been lifted. Did you not?
If I said that, that was completely taken out of context and was meant for some other reason. There was a lot of help and a lot of support where I could have justified saying something like that. I am not a cold person.
You understand the anatomy of a neck.
Yes.
You know not to put pressure on both carotid arteries. Correct?
Yes.
Thank you. No further questions.
And the jury just didn't buy it. But let's see what our power panel has to say about his presentation. Let's bring in trial attorney and former president of the National Bar Association, C.K. Hoffler, family law attorney and professor Randy Kessler is with us, and board-certified forensic pathologist and medical examiner Dr. Jan Gorniak. Great minds to be breaking down this case in particular. So glad to have you on. C.K., let me start with you. Your opinion of Fire Chief West on the stand.
Well, I just don't think he was very compelling in the totality of his testimony. He did great on direct examination. He was very graphic, very dramatic. You know, Julia, that was quite impressive. But you see, it's the cross that makes the difference. And that question, now you told your best friend XYZ, which completely annihilated all of his direct examination. You see, that is why these defendants don't need to be on the stand, because a great lawyer who does cross-examination in 5 minutes can destroy their position, and that's what happened.
And Randy, what do you think? What's your opinion of whether or not he hurt himself? We know the jury didn't buy it, but do you think that that made it worse for him?
I'm not as strong in this as CK is. I mean, cross-examination is absolutely where you can undo, and obviously it worked here. I think he had to testify. I mean, I don't think this is a case of because he testified, he got convicted. It sounds like he was going to be convicted. So, you know, when you're in that room talking to your client about whether they're going to testify or not, it's not a question of, you know, how good are you going to do? It might be a question of, you ain't got no choice because it's already looking pretty damn bad for you, and you've got to give it your best shot.
Yeah, but it can look worse. It can look worse.
I've seen worse than this.
Well, I've seen worse than this too. But I think in this instance, and of course, hindsight is 20/20.
Yep.
But I just don't think he should have taken the stand.
You think he would have not got? You think he was getting off the hook without taking the stand?
I think there was a better chance that he could have. There could have been something different.
If he had you as his lawyer, maybe making the argument.
No, I mean, you know, it could have been worse. But this little situation, him testifying, I think for certain put the nail in his coffin.
This was supposed to be a battle of the experts. That's kind of what we talked about this case, because it's seizure versus strangulation. Right. And we've got the perfect guest with us joining us remotely. Dr. Jan Gorniak, you have been a medical examiner in many counties across the country, and you've looked over what we have in this case from, let's start with what the state had in terms of the medical examiner, the autopsy, all of that. What did you take on this look at the evidence?
Well, good evening, everybody. This was an interesting case, and like you said, it was a battle of the experts, or it was supposed to be. The state medical examiner, I was shocked that she didn't find those injuries on the quote-unquote first go-around. When we get a body, right, we examine the whole body from head to toe. I believe she had a little bit of tunnel vision because it did come in as she had seizures. We have a lot of cases where people say, oh, I saw them having a seizure. It's not really a seizure, it's the process of dying, having a lack of oxygen to the brain. So she had tunnel vision with, looking for a seizure and not looking for anything else. She shouldn't have missed the petechiae on the face. She shouldn't have missed the internal hemorrhage, especially near the esophagus. And then we never, ever, ever release a body until we know we don't need it again. And so for her to have released the body and not hold on to it, for it to almost get to the funeral home, and then it comes back. Why does it come back? Because they got more information. And to me, that seemed a little biased, because now they're like, oh, we have some suspicion. So now all of a sudden, her findings, she finds them. Why didn't you see that on the first go around?
I'm so glad that you mentioned that, because our Court TV viewers have actually said that. You've answered a question for them because they've wondered, why did the medical examiner have to go around a second time? Because it was not deemed asphyxiation or strangulation until the second pass. A closer look by the medical examiner. What do you think happens on appeal in this case, CK?
Well, I think that's going to be a strong issue on the appeal. And the reason for this is, well, see, the record is going to be important. And I don't believe, and with the defendant testifying, he basically diluted all of the evidence, I believe, and all the strongest position he could take, because he's making it a factual issue. It is an issue with the experts. Did they lay the proper foundation? Did this expert actually, when there are challenges, did they use a proper methodology? When you have someone coming back, well, I forgot. All of that goes to the credibility of the expert. Now, a judge has the ability to determine the credibility, but the methodology used by the expert, that's something that could be very, very strong on appeal. But globally, when the defendant testified, Julia, I think that he diffused all of that, mixed it up, because he wanted to show with his superior knowledge, because he has that knowledge, and demonstrating on a corpse all of this. Why would he do that? He's just opening himself up. He actually gave the jury a visual of how he could have done it.
Let me tell you why he would have done that.
Okay.
There is a reason. Motive played too much of a part in this case. You don't need to prove motive to find that somebody did it. You need to prove that he did it. But this case was all about motive. He wanted her dead. He wasn't remorseful. They didn't like him. He had to make himself likable. He may not have accomplished it, but
likable.
They did not like him. They
and
did
of
not
course,
like him.
it's up to the attorney. It's up to the client.
And we went in the room with the lawyer.
We went in the room with the lawyer. Not likable.
Let's take a listen to some of the reaction that happened after this verdict. I'm going to get right back to you, Dr. Jan, because I do want to hear what you say about the defense expert. Let's listen to one of the victim, Marcy, her co-worker, reacting to this verdict and what the loved ones of this victim have been through.
I worked with her for 20 years. Marcy was one of the kindest, sweetest people you would ever meet. She always had a smile on her face. She never missed work. She never had headaches. She was always there. I think her and I were the only two that never got COVID.
She was very reliable.
Very reliable. She loved her children so much. We were planning a wedding when this all occurred, and it just has been 2 years of hell. I'm just thankful that the jury saw through all the stuff, and finally justice is going to be served.
What a journey this has been for them, no doubt. But Dr. Jan, we mentioned the defense. This defendant had a lot of people supporting him, his own mother, his children. Everyone took the stand saying that, yes, he was a cheater, but he was not the villain here. And they brought their own forensic pathologist, hired someone like yourself to come in and dispute the medical examiners. What did you take of that? Was there any credibility to what they said on the stand?
After reading the doctor's report or testimony, I was shocked. The questions were all more around the seizure, and not the massage. They had his son up there demonstrating how this massage, it's ridiculous. I mean, ridiculous. I think we all have had massages, even those deep muscle massages. But more likely, if you want to say someone could have a stroke that led to seizures, wouldn't be if you had told me she had just went to the chiropractor, because there are studies and evidence that happens there. But they harped on the seizures so much, and I didn't understand why, because she didn't have a seizure. She didn't have anything anatomically at autopsy in her past medical history, but she did have signs of injuries. And the defense expert agreed there were those other injuries, but I'm not even sure what her purpose was.
CK, I'm going to give you the last word on this one. What do you think about what Dr. Jan is saying about the massage being part of the defense, which it was?
Right, and I think that's ridiculous. They should have attacked the methodology. I mean, the massage. Most people have had a massage. Many people have had a massage. But had they attacked the methodology in a more methodical way, I think they would have had a better shot.
All right, we will see what happens. We've got a February sentencing date for former Fire Chief Kevin West. We will bring you all the latest here on Court TV. Up next, we're heading over to New Jersey for the Mansions murder trial for Paul Cadero. Day 5 is bringing disturbing images and a frantic 911 call to this jury. They listened to it for the first time, and we will break down some of the most compelling evidence after this break.
The Court TV podcast will return.
Welcome back. In New Jersey, it was day 5 of testimony today in the Mansion murders trial for Paul Canero. Now, he faces 4 counts of first-degree murder in the deaths of his brother Keith and his brother's family, his wife and 2 kids. Prosecutors allege that he fatally shot Keith and his wife and stabbed to death his niece and nephew. This all happened on November 20th of 2018 before setting the house on fire. Now, they say he then returned to his own home and set it on fire to create the appearance of a targeted attack against both families. Now, the jury was presented with a lot of evidence today, and this also came from that fire. So let's get to what our team chose as the most compelling evidence, starting with these jarring images shown in court today of Keith Canero's mansion engulfed in flames. A former neighbor also testified today about seeing these flames, and the jury listened to that neighbor's 911 call after finding billowing smoke and a body at the home. Take a listen.
I opened the door, and there is smoke's coming out, and there's a person laying down.
Where are they laying down?
On the property.
Can you get over
in
to
front
them?
of the house.
All right, get over
yes,
to
I'm coming over.
Okay.
Oh, my God, there's blood here. It's a corpse.
It's what?
It's dead.
What's dead?
Somebody is dead here.
Okay, sir, you need to get to a safe area. Hold on a second.
All right, let's bring back in our power panel, see what their opinion is of this evidence today. C.K. Hoffler, Randy Kessler, and Dr. Dan Gorniak with us. C.K., your opinion on how evidence like this, you heard there, the neighbor finding a body in the yard. It ultimately turned out to be Keith Canero, the brother here. How does that impact a jury?
I think it impacts the jury significantly. In fact, that the jury can never unsee that, Julia, because they're looking at that, they're looking at this testimony, they're listening to the testimony, they're looking at the body, they're seeing the evidence, and they're seeing the smoke, and they're envisioning what happened, and they're looking at that defendant. It's hard to undo that evidence. I think it's very compelling.
You know, fires, there's just something about them, Randy. When we see them, it's something that even people in media understand the interest people have in seeing those kind of images and just how they get at you. But the defense doesn't deny there was a fire. They deny he's the one who said it. So how compelling is it for guilt or innocence?
It makes good video, right? The towering inferno, these movies of, you know, ships blowing up and fires. Yeah, everyone sees it and it makes you more passionate. It's not what convicts him. It doesn't mean he was more likely to have set the fire than not to have set the fire. There's nothing about seeing a fire or hearing someone call 911 that says he's more likely to have done it than not. That's what the defense has to say. They have to get away from the passion and back into the fact of the matter is we're all upset by that. We're all excited and fearful and don't want that to happen to us. But that has nothing to do with my client. It has nothing to do with connecting the defendant to the crime.
Negative. And the prosecutors connected the dots. See, that's
but
the
not
thing.
that fire. That fire didn't do it in and of itself.
Yeah, but no. And the reason why I said that, and I love you, I really do.
Right.
But the prosecutors connect the dots, tell the story. Then the jury is looking at the defendant, and they don't have to do so much because there's towering inferno, like you said.
Dr. Gorniak, let me get your opinion on this, because the prosecution's connection of the dots here is that they're telling this jury that Paul Canero set his own house on fire, that he went to set his brother's house on fire to cover everything up. How does that impact a medical examiner looking at these bodies, which were stabbed and shot, if a fire really could take over the whole house?
So our job as the medical examiner, forensic pathologist, is to determine cause and manner, right? We cannot say whether someone set the house on fire or not. We have to rely on arson investigators, police, to say it was an arson, and then be able to determine that those cases will be ruled homicides. But I don't understand. I think it would be hard as a juror, right? As a lay person sitting here watching, or just looking at this picture of the billowing smoke, the fire, knowing there are kids in there, knowing that they were stabbed first, knowing that they're trapped in that building. So I know it doesn't point to who set the fire, but as a juror, I can just only imagine them sitting there and imagining not only the body outside, listening to the 911, the neighbor discuss, seeing the picture, just knowing, like you said, connect the dots. But unfortunately, when they connect the dots, there are 4 deceased family members that were killed, allegedly killed at the hands of a family member.
Yeah, no pun intended, but that legal term, inflaming the jury, that's something that certainly can happen here. CK, I want you to take a look at this next piece of evidence that came out today that was pretty compelling. These are images of a lurking person outside of this house before this fire was set, before the home's generator was turned off. So another image that was shown is the image of a garage door capturing was believed to be a person around the residence prior to the incident occurring. The timestamp on that is 2:36 a.m., so the wee hours of the morning, the day of the fire. Now, the image of the generator shows that it had been disabled and in the off position. And prosecutors say that Paul Canero went to Keith's house, cut the power, disabled the generator before killing the family. So you can't make out much in that picture at the garage door, but how compelling is that?
Well, you see, this is where you have this kind of circumstantial evidence. That person looks like it could have, sort of, maybe should have been, maybe the defendant. Potentially. At least they're going to try to make that argument. But I don't think this is as compelling of evidence. It's the image, because you really can't say that it looks like the defendant. You can sort of surmise, but I think it's got to be clear. But the fact that the generator, that the generator was disabled, all the other things do point to someone who was very methodical, intentional, and if they connect the dots to this defendant, then he's going down, in my impression. And I think that's what they're doing.
Randy, does it mean it's someone who's very familiar with this property?
Maybe, or maybe not. Someone who had to figure out their way around. I think it only helps the state if the defense says it wasn't arson. If they say it wasn't arson, this shows that it was arson, that there was somebody planning it. But I agree with CK. This is not, you don't hang your hat on this and say convict him because that proved it was him.
Dr. Jenaé, I'm going to get your opinion of this last piece of evidence we're going to show, and this one may be the one that connects the dots the most. It's the round of ammunition found on the ground outside of Keith Canero's family home, so of course the victim's home there. Investigators say this 9mm ammunition was located in Paul's home as well and used in the murder. So matching ammunition at the home of the victims and at the defendant's home. How do you all use shell casings, projectiles, things of that nature when it comes to examining a body?
Well, when we do the autopsy on, especially on anybody who dies in a house fire, they're going to get full body x-rays. And we'll see projectiles on x-rays if they're still in the body. So our job is to recover that evidence. It's very important that we recover all the projectiles that are in a person and turn them over to law enforcement and crime labs so they can make a comparison. So not only is the body evidence, but what we obtain from the body. So if there's any, or even like a knife blade, like the children were stabbed. I'm not sure we heard about a sharp forged instrument. So sometimes the tip of the blade can come off in a body. So we have to collect all that evidence, and then crime lab can piece them together and say this projectile is consistent with this weapon.
CK, is this enough? Does this get you to beyond a reasonable doubt?
I think it does. It does connect the dots in a pretty compelling way, Julia, for this reason. Same type of bullet, you know. This is the same as that. If I am the prosecutor, I might have them up 50 times showing these 2 bullets. Same bullets, different location, in his house, in their house. And I also would have all the pictures of the kids. You see, these children died. He wiped out, potentially, arguably, an entire family. An entire family. For what? Then we get to the real reason. What was going on? What was the motive? Money is at the root of all evil. Why would someone allegedly do all of this but for the fact that he was going to lose everything? He's going to annihilate a whole family, including his own blood. Horrific. And so these 2 little bullets, man, I'd be parading those around
Might be the only smoking gun. Randy, your final opinion on this one?
Motive is not required to get a conviction.
Not required.
Not required. It does help explain things.
But if it's great, it's there. Hey.
It does help explain things, but I think the bottom line is, the flip side is, it was his family. Yes, there was motive. But on the other hand, you got to get a jury to believe this guy did this not just to strangers, this guy did it to his own family. It's always a little bit harder for a prosecution.
All right, we will continue to follow that case. It is still going out there in New Jersey. But up next, we are going beyond the gavel, breaking down the biggest true crime cases. Timothy Busfield, this was a big headline today. He made his first court appearance in his child sex abuse case, and there was new audio that was played in court with the voices of his accusers. Stay with us.
Now, back to the Court TV podcast.
Welcome back. We are taking you beyond the gavel to those cases that are still being investigated, haven't had a trial in front of a jury yet. But this is in New Mexico. A disgraced actor, Timothy Busfield, he made an in-person court appearance today for a detention hearing. His wife, actor Melissa Gilbert, was also in attendance to support him. This comes after Busfield turned himself in last week and is facing 1 count of child abuse, 2 counts of criminal sexual contact with a minor. And these charges stem from allegations made by the parents of young twin boys, saying he inappropriately touched them on the set of a TV series he was directing. But in audio played in court today, the boys can be heard telling police specifically what their response is to whether or not they were inappropriately touched.
You know what's right and wrong, right? You know where people can't touch, where people can't do. Yeah, you know that, right? Does Tim ever do that?
No, he's never touched me.
Never touched you?
Yeah.
In like, you know, your private areas, right?
Yeah.
Never did that?
Never.
Okay.
Let's go on, Your Honor, to Defense Exhibit AA. This is 5 minutes later, separate. The boys were separated. The same police officer, this time speaking to SL, out of the presence of his brother.
So, you know what's right and wrong, right?
Yeah.
You know no one could touch your private areas?
Yeah, but he doesn't touch them.
Doesn't touch your private parts? Okay.
That's not, Your Honor, a failure to disclose. That's an express denial.
Now, that was defense evidence today. And important to point out that the prosecution said there were other therapists who talked to these boys who got a very different response from them. And today there was a man who worked on the same show as the alleged victims and Busfield. He testified saying it wouldn't have been possible for the actor-director to inappropriately touch anyone on set because there's so many people always around and always with children. He also said that the boy's father made him feel uncomfortable by forcing relationships between the children and the adults on set. Now, the judge ended up denying the state's motion to keep Busfield behind bars, said that he is a danger, but that there are restrictions that could allow him to be released. And these strict conditions include that he is allowed to travel, but he has to have weekly contact with his attorney. He has to be supervised by the pretrial services there in Albuquerque, and he can have no contact unsupervised with minors under the age of 18. Take a look at this. This is Busfield's wife, Little House on the Prairie star Melissa Gilbert, reacting to that decision. The judge ruling that her husband could be released on his own recognizance pending a trial. Let's get opinions from our guest panel. C.K. Hoffler, Randy Kessler, and Dr. Jan Gorniak. C.K., your opinion on the judge's decision to release him?
I think the judge was lenient with him for this reason. Even if the judge felt that the evidence wasn't compelling enough to keep him incarcerated, an ankle monitor, something more significant to ensure that this alleged defendant doesn't do anything. These are children. Children don't have the ability to fight for themselves. These allegations are pretty significant. You've got the parents making the allegations. Even if there's countervailing, there's different testimony from the kids, you still have to realize they're children. So when you don't know, when it involves minors, you've just got to operate under abundance of caution. And I think an ankle monitor is something more than just you're able to go, supervise visits, stay away from the victims. That, I think, is not sufficient. So I was surprised at the leniency of the judge.
Randy Kessler, your opinion?
I think it's very interesting, right? Today's hearing was not about guilt or innocence. This wasn't, oh, if he's innocent, he gets to go free. If he's guilty, he stays in jail. That's not what today was. Today was, how can we make sure this guy doesn't run, escape, hurt somebody else, and comes back to court? And if we satisfy all those, that's what the judge's job to do is. But you know, you can't get away from the judge. If the judge really thinks he did it, the judge is less likely to let him roam the streets. And if the judge thinks he's less likely to have done it, the judge may be more lenient. So I think this may be a little bit of an indication of what we may see, or at least what the judge is thinking about the case. But I agree again with CK, as hard as it may be, maybe an ankle monitor, maybe something, but you know, also he's a famous person. It's harder for him to get away. On the other hand, he's got money and he's well funded, so maybe it's easier for him to get away. I don't know that it was the right decision, but this was not a guilt or innocence day today.
And Dr. Jan Gorniak, let me ask you this, because from the forensic side, this seems to be a difficult case. The different forensic interviews of the children, it took time through their therapy for them to reveal certain details. And the prosecution pointed out that it was not the parents that initially came to police or to Child Protective Services, that there were mandatory reporters who reported it. How does that bode when you look at this case from a forensic standpoint?
And that's a great point, mandated reporters. As a, at school teachers, counselors, nurses, doctors were mandated reporters, and you're better off reporting than not. So, and they reported and they investigated. So this doesn't seem like, okay, they willy-nilly, somebody reported this and now this man is in handcuffs trying to say whether he should stay in jail or not. Obviously, there was a thorough investigation, and that's why we're here at this point. But it sounds like they had a forensic child psychologist who can interview the children and get them to articulate what happened compared to, I know law enforcement goes through training, but obviously there's differing stories, but hopefully the children are safe, not only physically, but mentally and emotionally.
Oh, yeah. That is the most important thing here. I want to shift gears just a little bit to talk about the wife of the defendant, Melissa Gilbert. She was in court. She did not speak today, but she did send a letter to the judge, one of the character references for this judge to consider as he faces these sex abuse charges. In this letter, she said, "I only want this extraordinary man safe and whole. So I will close by asking you to please take care of my sweet husband. As he is my protector, I am his, but I cannot protect him now, and I think that more than anything else is what is truly breaking my heart. I am relying on you to protect him for me." And there were apparently 80+ letters that were written in support of this defendant. And again, they come from people like his stepson Michael, his former 30-something co-stars Ken Allen and Peter Horton. I mean, a lot of people. 80+ letters is a lot, CK. And I know you do work with name, image, likeness for these up-and-coming celebrities in the sports realm. How do his attorneys who are trying to protect his image having to work behind the scenes on a case like this?
I think that just what they're doing, getting a lot of letters of support, that's very, very important at this stage. It could come back to bite them, though. And maybe because the evidence, maybe the attorneys are saying the evidence is not so compelling today. But I think they've got to be very, very careful, because the celebrity of it all, Melissa Gilbert, Little House on the Prairie, we all remember that. Oops, I'm talking about my age. But anyway, I think that can be pretty compelling at this stage. But they've got to be very careful, because jurors down the line can be very sensitive to the manipulation of Hollywood, if you will, celebrities, and people who have money. When it involves children, there's a whole different set of rules. So they got to be real careful, because it's not about his image. It's really about protecting the children, not about protecting this adult, but protecting the children.
Right, and he can have no contact with these children. That's another part of his conditions. Randy, final word in 30 seconds. What did you think about the letter and the tone?
First of all, what was that show? I really don't remember that show. Anyway,
Little House on the Prairie.
I think that letter, it's sort of like, envision you come into a courtroom and you're the judge, and there's one side and the other side, whether it's criminal or civil. One side has nobody supporting them. The other side has a room full of people saying, we are on his side, we want him. Letters can't hurt.
Letters can't hurt, and there's more to come in this case. We will continue to follow it out of New Mexico. We've got to take a break, but coming up, hot takes and cold facts. Our panel giving their opinions on the biggest cases, and this includes a mother who has handed down her sentence for killing her own teenage son, the trial of a man accused in the killing of his brother-in-law, and a wanted Texas man arrested while wearing clothing with an ominous message.
This is the Court TV Podcast.
Welcome back. Let's get right to some of the biggest legal headlines developing today. Before we get our panel's hot takes, here are the cold hard facts on our first story. A Michigan mother who claimed she killed her son, quote, out of love, received her sentence today. Katie Lee is going to serve 60 to 90 years in prison as part of a plea agreement to a second-degree murder charge, torture, and resisting officers charges. Her son, the victim in this case, Austin Picard, was just 17 years old. Lee claimed that he tried to take his own life before his 18th birthday, and she just wanted to help him achieve that. Her defense said her mental illness was spiraling after years of isolation and paranoia. Here's what she said in court when given the chance to speak.
To our friends and family, and the friends that are family, I'm sorry for blindsiding you with such heartache. I can only begin to imagine what this has put you all through. I know there are no magical words to make it better. I've started 100 letters trying to, but it never seems right.
Let's bring back in our power panel. They each have 25 seconds on the clock so we can get to all the stories and to everyone. We have C.K. Hoffler, Dr. Jan Gorniak, and Randy Kessler. Randy, I'm going to start with you. 25 seconds. What's your take on this plea deal for a mom who admits to killing her own son?
It saves everybody money. It saves everybody time. She's going away for the rest of her life, so I'm okay with it. The magic words she could have used were whatever the magic words are before you commit whatever the suicide is. You know, she should just say, I'm out. I've done wrong. I don't deserve anything in life, period. She messed up. 90 years. If she makes it that long, then I hope she suffers.
60 to 90 years is what she's being sentenced to. Let's go out remotely to Dr. Jan Gorniak. Let me get your opinion, reaction, take on this case when we do have this mental illness peg. And they didn't necessarily say this was because of the isolation during COVID, but they said her isolation started in 2020. Do you think that had a great impact on how the prosecution offered a plea deal in this case?
I would say yes. She admits she was an agoraphobic. She hadn't left the house in months or years, I can't remember, and she thought the FBI was after her. So mental health is real, and we have to look at it. It's okay not to be okay, and we have to remember to check in on our friends and our families, especially those with mental health and the strong ones.
All right, CK, final take on that particular story. I mean, it's a difficult one. Do you think prison is the appropriate place for her?
I think she has real mental health issues. That doesn't discount that she brutally murdered her son, but mental health is real. We tend to downplay it until it happens to our family, right? So mental health is real. So I would say she should probably be in a psychiatric institution, and then once her mental health is restored, go to prison.
All right, that's the take from our panel on that story. Let's move to our second story. This one out of Utah. The trial for a man that's accused of killing his brother-in-law in a plot involving his sister and mother began today. This is Kevin Ellis. He is charged with murder, obstruction of justice, and possession of a weapon in the death of his brother-in-law, Matthew Rastelli. Matthew was a father who was coming to do a custody swap with his children. And this defendant admits that he shot Rastelli 7 times, but says he did it in self-defense. Now, Ellis's own sister, who is serving time in prison after pleading guilty to murder and conspiracy, she took the stand today as the state's first witness. So that's going to be a huge moment for these jurors. Let's bring back in our power panel. Randy, let me start with you. This is one of those cases where the offending weapon was in the other hand of the victim in a case where the defendant says this was self-defense.
1, 2, 3, 4, 5, 6, 7. Self-defense, that, 1, maybe self-defense. 2 shots, self-defense. 7 times? That sort of defeats the self-defense. If I'm the state, I'm happy that it was 7 times. If I'm the defense, 1, 2, 3, 4, 5, 6, 7, I'm saying as fast as I can and saying he didn't know what to do and he just shot. But 7 times sounds like way too much to be defending yourself.
Dr. Jan Gorniak, this one has been dubbed the Utah Adelson's case. And I know you're out there in Florida. You followed that case very closely. What's your take on this one and how the intersection with the Adelson family, those Google searches that this family did of the Adelson family, how that's going to impact the jury?
This case, just like the Adelson case, blows my mind. The main thing that comes out of this is how do you get whole family members to participate in murdering a son-in-law, an ex-husband, a soon-to-be ex-husband. I don't understand it. One person in the family should be smart enough to say, hey, this is not a good idea. Maybe I should call the cops. And I have nothing, Julia. I don't get it.
CK, your take.
Family counseling. Have family counseling. Somebody had to say, we do not need to do this. We're going to get caught. Number one, nobody did. 7 shots, I'm with you, Randy.
All right.
How does that work? 1.5, maybe 2, but not 7 shots. See, that does not, common sense is being defied. It's not going to sell to a jury. Jury's not going to believe it.
And at what point do you recognize that it's your brother-in-law? Let's get to our third and final story of the night, and you've got to take a look at this one. Out in Texas, a man wanted in connection with a woman's death was taken into custody wearing a T-shirt bearing this ominous message. This is Cruz Dean Wancer. He was arrested January 15th by the police, and he was at the time wearing this hoodie with the phrase, "I will put you in a trunk and help people look for you. Stop playing with me." Now, according to the records, he was considered a fugitive in connection to the suspicious death of a 37-year-old woman, Margaret Pennington, who was found dead in her home. Dr. Gorniak, let me start out there with you. Your reaction to this hoodie?
I bet a lot of courties out there have this hoodie, the T-shirt, a koozie, something. I have my friends who say, "Oh, you're a forensic pathologist. You can make it look like an accident." I bought my friends all T-shirts that say, "Will you be my alibi?" The answer is no. I wear it. It's a fun shirt to wear around Vegas, but serendipitous. Everybody. I don't think it was meant for anything.
Randy Kessler, your take?
Oh, his heart had to sink, right? I mean, that's not the kind of shirt that you say, oh, it popped up on my Amazon feed or popped up. That's a bridge too far. I understand Will You Be My Alibi? Don't confuse your Google search with my law degree. There's some fun shirts. That one, you got to have something going on to want a shirt like that and to wear it in public.
CK, is it coming in as evidence?
It's coming in as evidence of stupidity. So this is the thing. When you have these shirts, have a shirt with your son like I do, his number playing football. But you don't have, when you have these propensities, these criminal propensities, do not have a shirt that says that, a hoodie on top of it. Not even a T-shirt, but a hoodie. Not good.
All right. Thank you to our power panel tonight, CK Hoffler, Randy Kessler, and Dr. Jan Gorniak. Thank you all for being on with us, and thank you for connecting with us this hour. I'm Julia Jenaé for Court of Opinion, reminding you that we all can have opinions, but we should be making sure that those opinions are rooted in fact, and we should be striving to hear the other person out, respect their opinions even when we don't agree.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.